Please, Lordship, item number 30, first hearing, 1331.
30 and
31.
Hmm.
So I took the consent, opposite party.
let us see.
My lord, my AK Pukasto is on leave, that is why.
One
Leave, he was on leave.
will appoint an amicus. The prayer rejected this next case.
May I please, Lordship? Item number 33. Carnatic advocate Encidas is out of station today.
Wait.
Hearing.
Wait, all these are 2012 matters. We do not know whether we can reach, but to no adjournment at this.
He is out of station.
Maybe. We'll appoint amicus.
May I please, Lordship?
Yes.
Lordship, I beg to mention item number 34, Lordship. Actually, Lordship, after the
No,
expiry,
all these 2012 matter rejected.
Lordship, but my senior D.R. Gogoi has expired, so we have to.
We'll appoint an amicus. No problem on that. Yes. Next case.
Yeah, please, Your Worship.
Yes.
On a 439 bail application, kindly. put tomorrow.
439, 438, motion, criminal petition, or allowed.
Maybe the Lordship, item number 29.
Yes.
I bet you it is for response number 2. We seek Lordship 3 weeks time to file an affidavit, Lordship. In item 29, we seek 3 weeks time to file an affidavit, Lordship.
Affidavit in criminal petition.
Lordship, I am for a complaint in Lordship. Affidavit in opposition.
What is challenge here?
If the proceeding is under challenge, the borrower has, after mortgaging his land.
Okay. On the prayer of MSR
Lordship P. Barua.
P. Borua, learned counsel for the respondent number 2, matters stands adjourned and be listed after 3 weeks. Interim order passed earlier shall continue till the next date of listing.
Lordship, a date can be fixed, Lordship. Deeply obliged.
My lord, I like to mention in respect of item number 21, my lord. My lord, I have submitted one additional affidavit, my lord. Day after tomorrow may be taken up.
Bail hearing additional affidavit.
Yes, your lordship.
Okay. On the prayer of the learned counsel for the petitioner,
Yeah.
matters stands adjourned and be listed on any interim?
No interim, my
No
lord.
interim.
Day-
What kind of additional affidavit you want to file?
Some facts.
CD is there, will look into. Anyway, on today,
Day after tomorrow.
on Friday.
Much obliged.
Friday.
May I please, Lordship, I beg to mention item number 35 of the daily list. The appointed amicus curiae is out of station, Your Honor. 80.
On the prayer of, on behalf of learned amicus curiae, matters stands adjourned and be listed. Inside jail or outside?
Jail appeal. This is jail appeal.
Jail appeal. Okay. List after 2 weeks.
Deeply obliged.
Lordship.
Yeah.
Lordship, I beg to mention item number 45, Lordship. Item number 45, I intend to withdraw, Lordship.
45 years.
Okay.
PA 1478.
Dismission withdrawal. 45.
Yes.
Yes.
My pleasure, Lordship. I beg to mention item 15, my lord,
15.
to be adjourned for the day, my lord. 15.
On the prayer of the learned counsel for the petitioner, matters stands adjourned and be listed after 2 weeks. Give dates are on all bails, give dates after 2 weeks.
15 adjourned.
Obliged.
15 no?
Obliged.
Yes.
Yes. Lordship. I
Yes.
think 27, my lord.
Item
27, my lord. Taken the concern of senior on the other side, my lord. Can they come the next week, my lord? There's an interim order.
on the prayer of Mr. Mahajan, learned counsel for the petitioner, matters stands adjourned and be listed on given date on next week.
Date that is. The CD was called for on the last day. Perhaps the CD is also not
CD is
available.
there.
CD not available. Not available.
CD not available in, then when?
Anja PS, my lord.
When?
6th of June.
6th of interim order pass earlier shall continue till the next date of listing. Yes, next case.
Obliged.
May I please, your lordship?
Yes.
I am 14 days behind the bar for
One
the
and three.
offense committed by some other
One and
person.
three, same.
One and
Lordship.
three.
Here, lordship may kindly peruse last two annexes. I am the owner of a jewelry shop. I have the trade license and I have the authority to do so. And lordship, somebody came to my shop with some theft good. And how do I know these goods
But
are?
gold you cannot purchase like that. That is the problem.
This cycle is going on.
You cannot buy gold like this. You are
No,
a.
no,
you are-
no, I never buy. I never buy, lordship.
Okay, CD, when? Item 1 and 3, isn't it?
Yes, yes, 1 and 3 minutes. On third minute.
Third.
Shortest date.
I'm 32 days behind the letter. FIR is at page lordship. Vernacular is at 14 lordship. The allegation is that lordship prior to 2 years ago lordship I have.
Third. You are Mr.
Yes, Ali,
S. Ali, learned counsel for the petitioner. Petition application under Swensu. Arrested on?
Arrested on 25th 4th 2024.
From the material available on record, it is seen that the informant and the accused are cousins in relation, and it is alleged that the informant has given an amount of rupees 10 lakhs to his sister, and the same money is not being returned. Full stop. Considering the nature of allegations and period of detention. To the satisfaction of
CGM Kamrup Metro. Lord.
CGM Kamrup Metro 25.
Deeply obliged.
34 days, my lord. Recovered, my lord. Page 13, my lord.
Okay, 19 years boy, 19 years boy.
What are the man already? On length of the 34. Length of the-
Only length of application. Swensu. It is alleged that the petitioner has stolen certain materials from the campus of backside of Soru Sajai Stadium. Is that it?
Yes, sir.
Soru Sajai Stadium. Full stop. The petitioner has been in custody since 23 for
34 days.
last 34 days. Full stop. It is also seen that the stolen materials has already been recovered. Full stop. Considering the period of detention. To the satisfaction of CGM Kamrup 10,000.
I am obliged.
May I please, Your Lordship?
Yes. Where is the FIR?
38 application. Lordship.
438. Where is the FIR?
9 minutes.
Lordship, type copy is on Lordship.
9.
Page 9 Lordship.
Page 9.
Lordship. Lordship, my name is there in the FIR, Lordship. There are four accused in the FIR. Allegation of theft, Lordship.
Theft or dealing with drugs?
No, Lordship. 380 and 34. Lordship.
That is different. Police has registered, but saying that you are peddling drugs and creating a situation in the area. Forget about the section.
Lordship, the allegation is
For need to use of drugs. For use of drugs,
They are creating this. Is not it?
for our, as and when we need consumption of drug, Lordship, it
you see
is
that
there
case-
in the FIR, Lordship. Lordship, my submission was.
Yes.
Lordship, the co-accused, Kukho Kutum, is already arrested in connection with the above noted case, Lordship. And he is my brother, Lordship. And
Okay, you are not Kusal. You are Lobo.
Lobo.
Both brothers be there together.
Lordship, we are twins, Lordship.
Be
So,
happy. Twins, you should not be separated.
Lordship, and my submission is, Lordship.
Ignorance. I know
as
that.
we look
because,
similar, Lordship.
I am also having a twin sister.
Lordship, as we look similar, my name is also included out of confusion, Lordship.
Both the name are there in the.
But you see the
Both
interim.
the name are
Okay.
there. On 7.
One has sacrificed. Okay, done. See the interim.
In time, Lordship.
Yes. 10
Highly
days.
obliged, Lordship.
7.
Application number section 438, Your Lordship. Now, Your Lordship, both these
Who are you?
Lordship, I worked in an NGO, Your Lordship. I have
This
incorporated.
NGO is very dangerous,
Lordship, name is
very
dangerous.
dangerous.
Lordship, name is dangerous.
From the symbol to everything. Yes, Daddy.
Lordship,
No, no,
Your
no.
Lordship, may kindly say 41 a notice has been issued. That means, Your Lordship, my arrest is not required.
Then
I am
why is
only
the apprehension?
apprehensive.
No apprehension. This correct.
Lordship,
41
no,
is
no,
your-
apprehensive. I am telling
Both-
Your
both
Lordship,
the way, madam.
apprehensive because Your Lordship, one of the person has been arrested, Your Lordship, in the same charges. That's why apprehensive.
rightly arrested.
Lordship. Your Lordship,
How
Your
can
Lordship,
this
kindly say,
kind of-
I have not placed Your Lordship
It
anything.
seems that you are police persons of not only India, some you are involved with America and all
Lordship,
also.
I have in this,
Your color is Indian, but
Lordship,
your symbols are.
I admit, Your Lordship, but Your Lordship, he is in fact, Your Lordship, he was asked to go there. That's why the FIR itself reveals, Your Lordship. Till then, Your Lordship, if everything something is, Your Lordship is there, Your Lordship will ultimately.
About Thakur Lanet we don't hesitate after even statement. I don't hesitate. Even
I
after-
know, Your Lordship, I know, Your Lordship, but Your Lordship, unless Your Lordship, it is not.
It is submitted by Mr. Borthakur Learned Counsel, huh? Huh?
Oh, sorry,
Oh,
I'm sorry. my-
Borthakur Learned Counsel for the petitioner that petitioner is not at all involved in the case, and police has issued a notice under section 41A to, however, he apprehends that he might be arrested. Full stop. Considering the above as an interim measure, it is provided that so and so subject to the further consideration after perusal of the case diary.
Deeply obliged, Your Lordship.
When? 14 June.
Deeply obliged.
Yes.
Wait, please, the Lordship.
Yes.
Lordship, this criminal revision petition is filed for the Zimma of the Kettle's Lordship, which was seized by the police on 23/2024.
Where is your application?
The applications are annexure 3 and 4.
Before the magistrate.
Yes, Lordship.
Where?
They were rejected on 4/4/2024.
When the kettles were seized?
23/2024.
23
2024.
23rd March.
March. And when
one
it
kettle
was when it was reported to the magistrate?
It was reported on 20
When do you get that?
in the
Heard
That is in the
MS
forwarded
Venture
report,
Learned
Lordship.
Counsel for the
annexure 2.
petitioner. Also, Mr. Parasar, Learned Counsel for the. Where is the order?
Order is annexure 5, Lordship, page
Yes.
25.
Page 26, 450 and 457, that is.
Correctly passed order. You are not
Yes.
disclosing under what provision, because there is a overlapping of two acts here.
That was a mistake committed by the advocate in the lower court below, Lordship.
Go there and file a fresh application.
Yes, my lord. Nothing,
How can I decide? Go and file a fresh petition there, and they will consider. Dispose of. You cannot be so casual. Learn from Mr. Datta. Yes,
Against the expiry order, my lord,
expiry order of what?
under 125 CRPC, my lord.
So why should you interfere? Interlocutory order.
Without, my lord, following the guideline of the Rajneesh, my lord.
That is an interim order. You go there, file
Order
it.
has been set aside by the Sound Court, my lord,
Huh?
because SSN liability was not considered before, my lord, come to conclusion, my lord.
Where is that? We'll issue a notice. How,
Only one date I took, my lord, time. He's a government employee, my lord. He has been engaged in election, my lord. So he could not appear.
we are issuing a notice. Is it a stage to declare all this? Interlocutory order is a interlocutory order is passed looking at the emergent nature or maintenance of a wife. Okay. Now you will have all right to file objection. Court will have all.
My written statement is, my lord, declined, my lord, not to allow to file in the impugn order.
That we can interfere.
Lordship.
That
That
we
was
can
also
interfere.
reflected.
That will interfere. What is your challenge?
Entire
Payment of maintenance or not
en-
allowing to file WS?
Well, entire order, my lord, we have challenged.
Entire order will not entertain. Third, we'll stay the further proceeding only on the ground that this is not done, but subject to condition that you will continue to pay the maintenance awarded. Then we'll know what is your interest, the filing of WS or payment. We'll stay the proceeding. No problem on that because you have not been given a chance. But interlocutory order will not interfere.
Lord, you lordship may remand the entire matter, my lord.
Without hearing.
That of course.
So that is the only option we can do this. And who will pay the cost to this lady who is not having even maintenance to come to this court?
Lord, she's claiming, my lord,
Ask your client how much cost for the stay of proceeding. Mr. Ali, learned counsel for the petitioner, prays for an adjournment. Prayer is allowed. Please this matter on next Monday. See, if you will give you a chance to file written statement whatsoever, Rajnish, everything will be followed. We may observe that. But we are not staying that interim order, number one. And how we'll have to pay some cost for her coming to this court. Yes, next case. Yes, what is this?
My
So
lord,
bulky a revision petition, tell us.
lordship, for quashing of the second FIR out of same incidents, lordship. Because which is against the principle of law, lordship, as the laid down lordship.
Two offense, where is the first FIR, tell us?
Lordship, page, first FIR is
22.
page 24, lordship.
20?
4. You have a given translation copy, just
20?
24.
my lord.
24?
Lordship. Annexure 1, lordship.
No,
Type copy.
bring us to the page, where it is.
Page 20.
We are not interested in the first form.
No, not lordship, this is a vital lordship cause of the date of occurrence, lordship. With all respect, lordship.
Yes,
Date of occurrence is 25/7/2019, lordship.
okay.
And in the FIR, second FIR, page 54, lordship.
Let us see what is the allegation.
Lordship.
22, my lord, type copy.
Huh?
Type copy, page 22. Particular portion, lordship, page 26, lordship. Married, lordship.
Yes, you read.
Lordship. Particular portion married, lordship, directly, lordship, page 26,
Date of occurrence is declared in FIR. Why should you go to the form?
lordship.
Huh?
Actually, just to official documents, lordship, for which বিনীত নিবেদন এই যে বৈধ 25/7/2019 তারিখে সকালবেলা মিজোরামস্থ বাইরেনটি আমাদের অস্থায়ী ঠিকানা হইতে আমার 17 বছর 5 মাসের নাবালিকা মেয়ে শ্রীমতী মমতা রায় বাইরেনটিতে স্কুলে যাওয়ার
Okay, I have read it. Now, what is the next FIR?
then next FIR, lordship, page 54, particular portion, lordship, page 57.
57.
57, lordship.
Where is the contents of the FIR?
Lordship, that is page 57, lordship. It is in particular, I will read, lordship, it is a type copy, lordship, drafted by an advocate, lordship. Dear sir,
Dispositive. What private respondent is required? POCSO.
No.
Nothing, Malad, it has to be that other thing may come, Malad.
What other thing? Let see. What they say is that this is the first affair. Then subsequently girl was recovered and she made these are the statements. That can at best be treated as a statement of the victim in connection with the case. Or they may take fresh statements. Matter ends there. Why should we stay the proceeding?
Lordship, in the first FIR, Lordship, already trial completed, I got acquittal, Lordship. Page, I have judgment annexed, Lordship, page
Oh,
39.
then there may be
I am not of that, Lordship, at any stage, Lordship.
That is
This honorable
2019
court,
first
because
meeting.
it is a continuation, Lordship.
No,
It is, I'll
2019.
rely on judgment, Lordship.
Don't go to the judgment
Sorry,
straight away.
sorry, Lordship. And apart,
Judgment will take help when we are
sorry,
confused. We have
Sorry,
not been
Lordship.
able to decide.
Lordship.
When law is clear, hard.
And
Let us for the time being stay
Further-
this proceeding. Mr. Parasar, see,
2019, now 2024.
no,
Okay.
there is a gap. But other part is that it arises out of the same incident. That she was kidnapped. After she came back, this is what she has described. So it is out of the same offense. Hard, Mr.
yeah, the Lordship.
Learned counsel for the petitioner. K. Majumdar, learned counsel for the petitioner. The present petition is filed assailing, seeking quashment of FIR in Dholai PS case number 195/2019. This is the new case.
Lordship.
What is the new? Where is the new case?
New case is that one, Lordship. Page
What?
5.
Tell us the number. It is
Dolai
PS
PS
case
case
number?
number, Lordship. Just time. Dolai PS case number 194/5 of 2021, Lordship.
not 2019.
Sorry, 2019, Lordship, dated 21/8.
And what was the earlier case?
Earlier case number is, Lordship. It is
These are the
172.
Lordship.
These are the
172 of
170 to 19.
Okay.
172.
Quashment of Dholai in Dholai PS case number 195 of 2019. Corresponding to GR case number 4414/2019, registered under section 420/370/34 IPC. Full stop. Prior to registration of the aforesaid case, an FIR was lodged by the informant against the petitioner, inter alia alleging that the petitioner has kidnapped the minor daughter of the informant. Full stop. Accordingly, Dholai PS case number
First
earlier,
one, Lordship.
172 of
172 of
172
of 2019.
2019 was registered. Full stop. After completion of investigation, search sheet was filed, and subsequently, after full length trial, the petitioner was acquitted. The subsequent affair, which is being sought to be quashed in the present proceeding, apparently arises out of the same incident. Full stop. Considering the above, let a notice be issued to the respondents. Full stop. Mr. Parasar accepts notice on behalf of respondent number 1, 2 by both ways. Okay.
Lordship.
Considering the matter in entirety, more particularly that both the affairs arises out of same incident, the petitioner, in the considered opinion of this court, the petitioner has been able to make out a case for an interim order. Accordingly, it is provided that the further proceeding in
Session case number 63 of 2024.
sessions case number
24.
24,
63 of 24.
63 of 24 shall
Pending.
remain suspended
Lordship. Against the petitioner.
against the petitioner. Why not others?
Sorry.
You want another
No,
petition? Take
Lordship,
fine.
no, Lordship. Not on that, Lordship.
Same incident.
Lordship.
What happened to the other?
NBW was issued
Suspended.
against me.
Let us see.
My lord, NBW may be
Suspended means suspended.
Suspended
Suspended, Lordship.
and
By order
Ah,
dated
Full stop. Registry shall call for the scanned copies of the record of the aforesaid session case. উপৰত আপুনি কোৱাচমেন্ট of the FIR ৰ লগত and session case number 3. So it's record of the session case numbers so and so and along with the case diary of Dholai PS case number 195 of 2019.
and as well as earlier case already.
Earlier you will have the judgment
Lordship.
acquittal, that's all.
Lordship, I pray Lordship, the order dated 24/4/2024 NBW was issued.
Suspended, full stop. Any
NBW.
order, any non-bailable warrant of arrest issued against the accused shall also remain suspended.
Sorry, Lordship.
Yes, next. Your petition was so bulky, but not to the point. Sorry to say that. Yes,
I'll consider that same Lordship.
Yeah, please, Lord, costing of the FIR and
item number
41, Lord.
41, sir, please.
Costing of the FIR in the charge sheet, my lord.
crossing of the FIR and search sheet.
The FIR page 20, my lord. The informant is the brother-in-law of the petition number 1 and the uncle of petition number 2.
Now, what is the ground of silence?
One of the main dispute is a family dispute, my lord.
Hmm.
Now, should we kindly first see one thing, my lord. Page 75, my lord.
Hmm.
Our operating account has been blocked, my lord. Before the lodging of the incident FIR. The account of my firm, my
What
lord,
is the stage of the proceeding?
it has been charge sheeted, my lord, and as
Charge
per instruction, cognizance has been taken, my lord. Summons have been issued, my lord.
Where is the FIR first?
Page 20, my lord.
Page 20.
20, my lord.
Heard. Mr. B.K. Mahajan, learned, N. Mahajan, learned counsel for the petitioner. The present application is filed for quashment of proceeding arising out of TRC case number 1281/2023 under section 406/420/34 IPC, which is pending IPC full stop. The aforesaid proceeding was initiated on the basis of an FIR dated
So Tinsukia PS 1987
24,
basis of
12, 21.
on the basis of an FIR lost by respondent number
2, my lord.
respondent number 2 before the officer in charge Tinsukia police station, which was registered as Tinsukia PS case number 1987/2021 under section 406/420. First stop. Perusal of the FIR reflects that the dispute is suggestive of a dispute arising out of a commercial transaction and prima facie subject to further consideration, subject to further consideration, makes out no case under section 406 and 420. Full stop. Considering the above, let a notice be issued to the respondent number 2. Let a notice be issued to the respondents. Full stop. Mr. Porasar accepts notice on 1, 2 both ways. Full stop. Considering the matter in entirety, it is provided that the further proceeding of so and so shall remain suspended. Full stop. Registry to call for the scan copy of order as well as the case diary.
Obliged, my lord. Highly appreciated.
It's a charge sheeted case, my lord. There are, my lord, in the charge sheet, my lord, 7 witnesses were there, my lord. And out of 7 witnesses, my lord.
Let us do one thing, Mr. Dutta.
My lord.
Just wait for some time.
Right.
This item 13 and 14 will take up a little bit later.
Right.
Let the other, you are already for long period,
Yes,
we will
yes.
go, we will have to apply our mind.
Right.
Stages are different.
Right.
So we'll, after some time, let us complete the bail hearing method. Because we are having a little
Right.
paucity of time today. Yes, item. CD receipt. Yes, where is the affair?
Lordship, CD was called for Lordship.
Huh?
CD was called for Lordship.
This is BA.
Yes, Lord.
Where is the affair?
It's 8 lordship.
Yes.
Stolen vehicle lordship already recovered and
Lordship,
How many days?
Lordship,
How many days?
15 days lordship. Arrested on
That is the
14/5
arrested on-
lordship. Stage 8 lordship FIR.
Oh, this is a new style. New style.
Lordship with the consent lordship from the informant.
Then why
vehicle
didn't you
was-
return the vehicle?
Lordship,
That's why I'm saying it's a new method.
Lordship,
Recovered vehicle
yes, recovered.
from whom?
recovered lordship.
He has led to the vehicle lordship. He himself led to the vehicle lordship.
On 15 lordship, vehicle recovered lordship.
Third. Swenso. This is an application under Swenso. The petitioner was arrested on
15/5 lordship.
14/5/2024. The allegation made in the affair is that the vehicle of the informant was taken away by the present petitioner on the pretext that he will buy the aforesaid vehicle. Full stop. However, he did not return the vehicle. Full stop. Subsequently, the petitioner was arrested. Full stop. The vehicle was recovered from his possession. Full stop. The case diary produced reveals that the petitioner has thoroughly been interrogated by the investigating authority. Full stop. As the vehicle has also been recovered and the petitioner has thoroughly been interrogated, this court is of the view that no further custodial interrogation of the petitioner may be necessary, inasmuch as the investigation has substantially been progressed. Accordingly, 25,000 to the satisfaction of
CGM Kamrup Metro.
CGM Kamrup Metro.
Yes, lordship.
Okay, Villa. Okay. Yes, Mr. Munir.
Intermediate quantity lordship on
How many days?
55, no?
55.
What is the period? 60.
60 days.
What is the stage? No case diary.
Only waiting for the FSL report. Otherwise, cases.
What is the case diary is with
Yes,
you?
yes, yes.
Let it be with you. Heard Mr. Munir, learned counsel for the petition. The present application is filed under Swenso. Full stop. Case diary was called for. Full stop. Same is produced. Full stop. It is alleged that small quantity, intermediate quantity of narcotics, that is, i.e.,
21B.
no. What is the material? Heroin.
19.99 gram.
And quantity of narcotics, that is heroin, was recovered from the possession. Auto rickshaw?
From his pocket.
You drive an auto rickshaw, but you consume. If you want to suggest that it's from pocket, but it's from a box, no?
Box, lordship. Green color, brown
The
color.
soft box.
Lordship.
Yes. Let him go.
Lordship,
What will you do within 5 days?
that is what lordship. We tried our best to get the FSL report lordship. Put down.
Well, on some cases, will take slow motor.
Lordship.
Either they are not having officers or they are delaying it. Okay, let him go. We'll see. Kikul. Position of the petitioner, who is an auto rickshaw driver. Full stop. From the case diary, it is seen that the investigation has already been completed and the investigating officer is awaiting for forensic awaiting for the report from the FSL. Full stop. The petitioner has already been in custody for last 55 days, in as much as the statutory period to complete the investigation is 90 days. 60 days, is 60 days, full stop. Considering the matter in entirety, more particularly the stage of investigation and the period of detention, this court is of the view that the petitioner be released on bail, full stop. Accordingly, ordered accordingly. Accordingly, the petition is to the satisfaction of
Special Judge, NDPS, Kamrup Metro.
Special Judge NDPS Kamrup Metro at add corridor, the petitioner shall not involve himself with similar nature of offense. That is why we want that all this should be made, statement should be made. Suppose on the next, suppose after a month, he was caught in Sanmari. He will come and file an application. I don't have any antecedent criminal.
Forwarding report, we can see, Lordship, that
But
the reference was
sometimes
given.
police will not write, na?
In some cases, there it is seen in the reference, Lordship. In the
And then we'll
FR.
ask for the earlier bail orders, any bail in similar cases. Certain things we'll have to incorporate.
Some of the cases it is seen in forwarding report, Lordship, that he was.
No, we are trying to develop it.
Much obliged, your Lordship. Much.
44 Lordship, charge sheet has not been submitted and CD has not received, Lordship. In the last occasion,
What is the, how many days? Okay, hard. So this is an application, taken in Likhiba, seeking bail, so and so. The petitioner has been in custody for last
84 days.
84 days. The period, statutory period to complete the investigation is 90 days, full stop. Case diary call for has not been produced, full stop. However, Mr. B. Sharma, learned additional public prosecutor, submits that charge sheet has not yet been filed, full stop. Considering the above, more particularly the period of detention, the petition, the present application stands allowed. To the satisfaction of
SDJM within bracket and Bilasipara.
SDJM within bracket and Bilajipara.
Wait, please, your lordship. Lordship, this is a 439 bail application, lordship. 7 days, lordship, on page 16 is the FIR, lordship. Manhole cover was stolen, nothing recovered from this petitioner, lordship.
How many days?
My lord, since 21/5, my lord. My lord, in these cases, my lord, what happened though it
No,
is.
I understand. These are, I have seen not only this manhole, then railing of footpath railings
Yes,
and all.
manhole cover, please.
This reflects the
On
economy.
the basis of my lord, in fact, my lord, those personnels, my lord, wearing the dresses of my lord GMC workers. And the local people of the locality thought that they are personnels of the GMC. Thereafter, my lord.
This reflects the state of economy.
Yes.
That is the problem.
Lordship, I am not involved, lordship, in this case, lordship.
Don't go to that. Who is involved, who is not involved.
Thereafter, my lord, on the basis of CCTV footage, my lord, one truck.
Yeah, they have done it, no doubt about
Yes.
this. But only question is that they have recovered, they have been caught. Now,
Yes.
to the satisfaction of
CGM Kamrup Metro, lordship.
how many days?
Lordship, 7 days, lordship.
7 days telephone. Considering nature of relation. Yes.
Highly obliged.
May I please, 430 application, Lordship, FI page 9, Lordship. Here,
Any interim?
no, Lordship,
No. Where is the affair?
page 9. We are not the name makers, Lordship. I am the employee of the main makers, Lordship. Diver as a diver.
Where is it is where is a vernacular?
Lordship, page
I am very poor in English.
15.
Oh, they have written like this, lordship.
Huh?
Particular 15 is like this.
We like to read
Yes.
our regional language. Yes.
এই যে আমি নিম্ন এজাহাৰকাৰী সকল নিবনুৱা আৰু দুখীয়া পৰিয়ালৰ লোক হওঁ নিম্ন আসামীগণ ও বেলতলা তিনিআলিত থকা বেংক অফ ইণ্ডিয়াৰ কিছুমান লোকে ও মেটেল অটজুন নামৰ ডিলাৰৰ কিছুমান লোক মিলি আমাৰ লগত প্ৰবঞ্চনা কৰিছে নিম্ন আসামী সকলৰ লগত আমাক চিনাকি শ্ৰী মনীষ ছেত্ৰী পিতা হৰিকৃপা ছেত্ৰীৰ জৰিয়তে চিনাকি হৈছিলো নিম্ন আসামীগণ ও মনীষ ছেত্ৰীয়ে আমি নিবনুৱা বুলি জানি তেওঁলোকে আমাৰ উপাৰ্জন ৰাস্তা কৰি দিয়াৰ বাবে বেলতলা তিনিআলিত থকা বেংক অফ ইণ্ডিয়াৰ শাখাত মাতে আৰু বেংক কৰ্মচাৰী আদিয়ে মিলি আমাক প্ৰত্যেকৰ নামত একোখনকৈ উক্ত শাখাত বেংক পাছবুক খুলি দিয়ে আৰু আমাৰ পৰা ভোটাৰ কাৰ্ড আৰু পান কাৰ্ড
Who is this?
My lord, yes, there are materials against these persons also. My lord, what they have done, my lord, initially there are very.
This is the state of economy. I'm saying these are the poor people. They said we'll give you your alternative things. You have a bank account. You will do some job. Money will come. Where money will come? That they in their name loan has been
Yes, now the accused person has used all those my lord, victimized persons, my lord, by using their name, their documents,
No,
my
that
lord.
is- that we have
They
seen.
opened, my lord, bank account. Thereafter, my lord, took loans, and thereafter in their name, they also by
Then
taking
this
all
bike,
these
then
vehicles, my
bikes
lord.
will go to
They
Bangladesh.
lease, yes, they leased all those vehicles. Thereafter, my lord, later on when they received notice from the bank, then only they came to know that in their.
But my name is Dr. Shahid and Tahid lordship.
Yes, what is the road side and
Your
title part?
lordship may kindly peruse the statement from here and next page also regarding the present two accused, my lord.
Huh?
And next page also, my lord. Their name is also reflected. My lord.
You are Abdullah.
No.
No.
I am
Abdullah,
the employee of the Abdullah lordship.
is
I put some signature in the agreement lordship because my employer asked me to. put my
Sahid
signature.
Ahmed and Tahir
Now,
Ahmed.
what about Abdullah?
Abdullah is my employer. He is
No, no,
absconding.
where is Abdullah now?
I don't know lordship. Absconding. He is abetting arrest lordship. Monish Hetri was arrested.
Your name is?
Shahid and Tahid lordship.
Sahid Ahmed and Tahir.
Tahir.
Tahir Ahmed.
We are victim of the circumstances. We will cooperate with the investigation lordship.
Your name is?
Sahid and
Shahid
Tahir.
Ahmed and Tahir Ahmed.
Tahir Ahmed. They are working under the instruction of main accused.
Abdullah Ahmed.
They are associate of Abdullah.
You are?
Shahid and Tahir lordship. Employee, I am a petitioner to be the driver of the Abdullah lordship. And I put my signature in some of agreement lordship.
You are cousin of Abdullah. Don't say employer.
Yes, associate. My lord.
Lordship, same village.
Main culprit is Abdullah
Yeah, Monish Hetri.
Monishetri Wajid.
Wajid. I am not Wajid lordship.
And you are cousin of the Abdullah.
Yes, also associate, my lord,
Ah.
from the statement.
Same,
my
from
lord.
same village lordship, from Moram Hati. In Parathi lordship, I have stated that I am a driver of Abdullah lordship.
Till Abdullah is arrested, we will not grant you bail. Abdullah and Shetri. Hard.
We will cooperate lordship, any condition lordship.
Hard, Mr. Spencer, and counsel for the petition. Full stop. It is an application under Swenso. Likiba, first of from it is alleged by the informant that the petitioners with a promise to the informant that the informant will have some income, that the accused will do something to generate certain income to the informants who are unemployed with youth, open bank account in their name. Subsequently, they could learn that in their name, loans were sanctioned for purchase of different vehicles, including motorcycle, and the subsequent full stop motorcycle full stop, and thus they have been cheated. Full stop. The case diary connected with the case is produced. From the case diary, sufficient material has been collected which suggests that one Abdullah Ahmed is the main kingpin, and one Abdullah and Monish Setri are the main kingpin. The modus operandi of the aforesaid group is that they target unemployed poor people and promise them with income, and accordingly open bank accounts in their name, full stop. And subsequently, loans were sanctioned for purchase of motorcycles, etc. in their name, and those motorcycles are sold in different states like Arunachal Pradesh, Nagaland, etc. Full stop. The material so far collected by the investigating authority further suggests that the petitioners are also assisting the prime accused in commission of the offences. Full stop. The prime accused, namely Abdullah Ahmed, is still at large. Full stop. Still at large, though Setri was arrested. Though the co-accused Setri was arrested. Full stop. Be that as it may, as the sufficient materials are there in the case diary, this court is of the view that this is not a fit case to grant privilege of free arrest bail. Accordingly, the present bail application stands dismissed. The case diary be returned.
Not only motorcycle, four-wheelers.
Four-wheelers that we have seen.
Yes, yes.
Yes.
Lordship will find the FIR at page 7, Lordship.
Yes, case there is there. Similar kind of bill we have dealt with. No, this is we dealt with.
No, last occasion, Lordship, I heard it. Yes, checked it.
This, yes, I remember, they are slaughtering without any permission and all this, and the rest they remain, they throw it in the pond.
What the villagers say?
The local people, they are locality 3-4%. They are all stated that they have no any permission and all this, and they are doing such type of business, and thereby they are.
Whether this is correct that they are throwing those residue of this meat in the pond.
Then thereby And this is a public pond, my lord.
Because of those offences are.
No, yes.
Which are available?
This
Okay. But what about section 8?
section 8, Lordship, and that is predominantly inhabited by the Muslim locality people. And this person, Lordship,
No,
he is not
that is not our concern.
he is not
It
slaughtering.
is not that suppose somebody eats goat. Will it be permissible? It is a Hindu religious village. Will it mean that they can throw and do these kind of things without permission? Suppose it's a requirement of law that you cannot slaughter a goat without permission. And this is a offense punishable up to 10 years. Forget about Hindu Muslim.
No, that's
It is
selling.
permissible that you will throw all this into the pond or village pond.
Lordship, this petition.
That may not be bailable. It may be bailable.
Lordship, what I am submitting, Lordship, this petitioner, Lordship, he does not have any slaughter home, Lordship.
That is the issue.
That is the issue.
They say you don't have any
He
slaughter.
purchased from the accused number 1 and he sells, Lordship. That is.
That also can. Sale, transportation is banned. That law holds the village on that.
But that is in respect of areas where it is.
No, not at
Yes,
all.
Lordship.
Bring the section 8. Who says?
No person shall directly or indirectly sell. or offer
No.
exports.
Without authority, nobody can, no place is concerned. Keep the this act.
Provided that no such permission shall be granted in such areas or areas where.
No, that is no permission shall be granted. There is an bar of granting permission. But permission is required anywhere.
Lord, whether in this case, Lordship, custodial interrogation will be necessary, Lordship. That is a question, Lordship, here. Because if I cooperate with the investigation and if I am punished or convicted, then only the purpose will be served, Lordship. What purpose will be served by
But
keeping
it's a
custody,
privilege. 438 is a privilege.
that
And we do
that
not
is
like
a
to give a
decision, Lordship,
privilege to a person who is
my submission would be.
your
whether-
behavior is a very important concern when granting bail under 438. 430 is not a right that no interrogation is required, therefore bail should be granted. This is not the
And
provision.
By his.
This provision was incorporated for misuse. So that persons are not unnecessarily arrested, not harassed. Now this has become a regular phenomenon. How can
The
that?
villagers has also.
Don't go to that. You read
no.
the 438. What is the 438?
Yes, I have, Lordship.
So if
Villagers are
438
also of same community. They are suffering. Matlab, it's not like that. Community and all this. They are suffering. They are stated.
police will not arrest you. Let their sword be above your head. Hard, so and so. What you say, Mr.
No, my lord, I have objection. Matlab, villagers also matlab, same community. Regarding community is this nothing.
What is
matlab.
section 8?
They are.
That is there, Lordship. He is selling without permission. That is there.
What is the offense, Mr. Period of,
Period is 3 years to 8 years.
now
Extended,
when it will be 3 years, when it will be 8 years?
It's not.
some restriction not less than 3 years and which may be extended to 8 years.
Now, when, under what circumstances? First offense, anything like prescription like that?
No, not specific.
Okay, we'll take it this matter 2 day after tomorrow. Please this matter day after tomorrow.
Thursday, Lord.
Thursday. Just have it because whatever order will pass, it will have a far-reaching consequence. So if it is 3 to 10, now when 3, when 5, when 7, when 10, why it is 3 to 10? Anything prescription that first offense is when so?
No.
Because there are some issues or some prescription where there is a first offender, second offender provisions are there. You just go through it. Because generally this is not like the 3 to 10, either 3 or 3 to 7. Then under what circumstances it will be 10? Gravity, something should be there. Because offense is same that without permission you cannot sell it. Yes.
Made a lot. Well,
438 application lordship, FIR is page 8 lordship. Petitioner is an interim lordship, appeared lordship statement recorded lordship. Page 8 is the FIR lordship.
Just a minute. AB or what?
AB lordship.
Interim is there, maybe, appeared, there appeared statement recorded.
Dispose of. Absolute.
Wait, please, your lordship. 438 application, your lordships.
Yes, where is the FIR?
This 20 is the FIR, your lordships. Annexure B.
18 and 19 same case.
18 and 19 are same year, out of same FIR as in out of the page 20, the informant
Any interim?
Interim is
stated in favor of me, your lordships, by the order dated 5/4/2024, your lordships.
appeared statement recorded.
Statement recorded appears considering nature of investigation materials so far collected. And also considering that the petitioner has cooperated with the investigating authority, recorded his statement. Absolutely.
19 is also same.
17 and
18
18 and 19, same.
Lordship.
Yes, Mr. Sharma.
The interim bail is already is granted, my lord. The case under section, my lord, 430.
Sharma.
But the only thing, Lordship, from his home, one seal has been recovered of State Bank of India, some stamp papers. The materials are there, Lordship. So these things are, and regarding this.
You have seized those?
Yes, yes.
So you seized those, you have statement
Yes,
recorded?
yes.
Okay.
My lord.
Dismiss.
My lord, one thing is this.
Dismiss. No order will be changed.
Okay.
Absolute, made absolute.
And one, my lord, that his bank account has been also blocked.
You file an application.
Filed application, they have not received it. Then we have.
No, you file an questioning or application under 482 or their actions in, we'll do that, not in bail.
My lord, only.
Not in bail, not in bail.
No, that is my only thing is I wanted to show only one case, my lord.
We'll
Yes,
see when your cases, that case comes to us.
no, that is, my lord, we have filed an application to them, but they have not accepted it. Then it is.
Ask your junior and send through a mail. Now everything is accepted.
That has been sent through post office, my lord.
Then come to us. Say that this is what they are doing. File a writ petition.
I only one.
That will be difficult
No,
in a bail application.
no, my only thing is that in this recent judgment of the three benches of the Supreme Court, only one paragraph I wanted to show, my lord.
Which judgment?
That is, my lord, the Supreme Court that is Siam Steel and Powers Limited and others,
Acha.
and Siam Steel and Industries Limited. That is then decided.
Okay.
Right here, right. That only on one paragraph.
Yes, read it, read it. Knowledge is important.
We find
Yes.
that it is high time that this court should take note of frivolous appeals being filed against unappropriable orders wasting precious judicial time. As it is the courts in India are already overburdened with huge pendency. Such unwarranted proceedings at the behest of the parties who can afford to bear the expenses of such litigations must be discouraged. We therefore find that the present appeal deserves to be allowed with token costs. The respondents plaintiffs shall pay a token cost of rupees 5 lakhs to the Supreme Court Middle Income Group Legal Aid Society.
We are also doing that. But in a appropriate case.
That is, my lord, here is also when they have filed an application that the salary amount is deposited in the said account. By that salary account, his two
But
children.
Mr. Sharma, in bail we cannot pass this order. That is the difficulty. Yes. Next case. Yes, what is this?
But in this case, your lordship passed an order. That order.
Where is that order? I is for what?
Just order is at page 9. Now, what happened in this case, the petitioner was implicated in a trial under IPC 420. Thereafter, he was acquitted in that case. Thereafter, again, my lord, the petitioner was implicated in a proceeding under 138. Be that as it may, when he has filed an evidence under section 145, he has not exhibited the documents. And at the subsequently, my lord, he wanted to rectify his evidence. At this time, juncture, we came to your before this honorable court, and your honor lordship also passed an order.
Now, what is the stage? Main case.
The proceeding before the learned trial court may
This
proceed.
proceeding.
However, the same will not be subject.
Who is for respondents? Respondent number 2. K. Borua M. Alam P. Das. Now, what do you want? You want a stay of the proceeding?
No, I don't want to stay the proceeding because your lordship has already indicated the indicator. So I do not want to give.
Now, what is your prayer in this side?
Let them proceed, but no final judgment should be passed. That is, of course, indicated by your lordship.
We have indicated.
But let it be clarified. Your lordship is clear. The proceeding before the learned trial court may proceed. However, the same will be subject to outcome of this case. One line may kindly be added that will.
Okay, we'll just pass that order. Let us take this matter. What is the next date fixed in this case?
I don't know.
You must know it.
Your lordship a short date.
Okay, we are thinking since other side is not there.
Yes.
Therefore, we'll fix the date on next Monday.
All right.
Okay.
Only this thing, because it is already indicated.
Though Mr. Dasgupta, learned senior counsel, is present for the petitioner. However, the respondent number 2 is not being represented by the learned counsels, though their names are shown in the cause list.
Yes.
Shown in the cause list. Accordingly, this matter stands adjourned in the interest of justice and be listed on 3/6/2024. Full stop. If none appears for the respondent on that day, the IA shall be considered in their absence. Yes.
Please, your lordship. Lordship, last occasion it was listed before this honorable court, and this honorable court directed the respondent lordship to take instruction. So whether they take instruction or not.
Mr. Das, we have granted him bail, huge quantity of NDPS. Now we put 2 conditions. Bail of 1 lakh and 2 surety. He says, I want 1 surety. So we saw that let the state have an instruction in this regard. Because we can relax it. He says that I can arrange 1, I will give the bail bond, but 2 is not possible. I am very poor man, this is not what. Or if you want a day's time, we can accommodate you also. Just we wanted his antecedent, whether there is scope for flying away or NDPS ultimately.
Commercial
That is why. Otherwise, if it would have been other case, we have been for day 1 without But since NDPS, we should give a chance to the PP. That's all.
As on today, Lordship, 75 days, Lordship, after date of.
After the bail.
Lordship.
Otherwise, he is a local man, madam.
Local man. That is what. Is not.
I live to Lordship.
Heard Mr. Ayush Choudhury, learned counsel for the applicant. Also heard Mr. MP Goswami.
Not my, no objection may not be recorded.
No, will not record. Agar order to you write up to paragraph 1, 2, 3, 4, 5. Okay. Full stop. Considered the statement made in the petition. Full stop. From the record, it is seen that the petitioner is a local resident of Corinthians under the jurisdiction of the trial court. Full stop. Jurisdiction of the trial court. The Honorable Apex Court, in the case of what is this referred as?
Suomoto criminal writ petition criminal.
Suomoto writ petition criminal number 4 of 2021 has dated 31/1/2023 has made certain observations as regards furnishing of bail bond and resultant release of failure to furnish bail bond and resultant release of the accused persons. The Honorable Apex Court has observed that if the bail bonds are not furnished within 1 month from the date of grant of bail, the concerned court may suo motu take up the case and consider whether the conditions of bail require modification and relaxation. Full stop. After considering this, the facts of the present case, more particularly the facts that the petitioner is a local resident and he is a poor person and has not been able to produce two suitable solvent sureties, though it is stated that he can provide one solvent sureties. In terms of this court's order dated 21/5/2024, this court is of the view that relaxation of the condition of two sureties will not prejudice the prosecution as well as not prejudice the prosecution. Full stop. The one surety will be sufficient to ascertain the appearance of the petitioners before the trial court, inasmuch as the petitioner has given an undertaking that he will remain present before the court, in the trial court in the proceeding. Considering the above, the present application stands allowed, and the condition of the two suitable solvent sureties is modified, and in place of the aforesaid condition, the following condition be read into the order dated 11/3/2024. The petitioner, namely inverted comma, the petitioner, namely Jamjam Hussain, comma, be released on bail on executing a bail bond of rupees 1 lakh within 1 lakh likiba with one suitable solvent surety of like amount to the satisfaction of learned special judge Karimganj, Assam. This disposes the IA. Timing.
My lord, I have one submission, Lord. My lord, this should not be a precedent for other cases.
Okay,
my lord.
okay. It is needless to say that this shall not be treated as a precedent
Only on special-
inasmuch as such order has been passed, taking note of given facts of the present case. Yes, Mr. Dr. What is this?
It's a charge sheeted case, my lord.
Where is the FIR?
FIR, your lordship will find at page 14, 1/4, my lord.
1/4.
The victim was 15 years, 7 months at the time of occurrence, and the petitioner is, my lord, 18 years, my lord. And they had a lab affair, my lord. After police investigation, filed a charge sheet, my lord, on 19/6/23, my lord. My lord, there are 7 witnesses in the charge sheet, and accordingly, charges were also framed on 9/11/23. And thereafter, trial started, my lord.
Just a minute. She has been examined.
She has been examined.
Where is that?
Informant and the victim is not person. That very same. It's in the record. But এখন she implicated, my lord. That's she implicated. There is no doubt about it, my lord.
Next step, please. Hmm? How many witnesses are examined?
My lord, out of 7, only 2, my lord. My lord, I am not on the merits of the case, my lord. There is a love affair, it's true, my lord. My lord, she is also 18 years old. My lord. Only one point, my lord, I want to point out, my lord. Page 26 of my petition, my lord, for a once.
Page 26.
Page 26, my lord. Page 26, my lord. She was referred for, my lord, medical exam.
That if you see it.
That part, my lord, I have nothing more to submit, my lord. Sir, in these cases, I never also submit, my lord, beyond my mind. Only thing is that, my lord, they had a love affair, my lord, admittedly, my lord. And till now, my lord, out of 7, my lord, 2 witnesses are examined, and he has been in the bars, my lord, for a year, my lord. And when the other witnesses will come, my lord, that is also to be seen, my lord. And so far, tampering the evidence, my lord, the victim and the informant has already been deposed, my lord.
What is the statement of the victim?
Victim, my lord,
PW?
PW1, my lord, I have supplied, my lord.
Are you having it?
Just now I have.
Okay. Why it is not in
Because there was an objection filed by the respondent number 2, Lordship. There,
Where is respondent number 2?
the deposition has been annexed in the affidavit, Lordship.
Birth certificate, লগাই দিছে ন?
You also extracted the explanation why she has not done medical test.
Yes.
But more is required.
Yes, that's why my lord, only thing is that, my lord, this deposition was my lord, was done on 8th of January, my lord, 24. Till now, my lord, no other witnesses has been called, my lord.
No further evidence is required in this case.
That's true, my lord. That's true.
Dismissed.
Only on that point, my lord, the medical was not done.
We'll pass this order later. Dismiss.
I am obliged.
No.
May I please, Your Lord?
Okay, heard Mr. N.J. Dutta, learned counsel for the petitioner. Also Mr. B. Sharma for the state, additional public visitor for the state, and Mr.
R.L. Sutia.
R.L. Sutia for the informant. Rest will pass, we'll get by Monday.
May I
Yes.
please, Your Lord? My lord, it's a 439 bail application, my lord, and it's a suscited case, my lord. And he's behind the bar, my lord, for
Where is
107.
the affair?
FIR is, your lordship will find at page 13, my lord. 1-3, my lord. It starts from 1-3, my lord, relevant portion at 1-4, my lord. 14, my lord. In fact, it's a consensual, my lord, relation, my lord, between the boy and the girl, my lord. And after lodging of this FIR, my lord,
Just let us understand. We'll come to the merit later on. FIR is at page 14.
respectful submission is that at about 6 o'clock in the evening on last 26/11/23, the below named accused by taking away my minor
What
girl
is the
named
stage of the trial?
trial, my lord. Charge not yet framed, my lord. Though charge sheet has been, my lord, late, my lord, 31/12/2023, my lord. It's now only remanding, my lord. So as for this FIR, my lord, she is 17 years old, my lord.
In fact, Lordship, the scan copy is not up to date, Lordship, if I'm not wrong, Lordship.
What is your age?
My age is 18 years, my lord. And in fact, in the charge sheet itself, my lord, the 164 statement.
Case that is come.
Lordship, scan copy is there, Lordship. Yes. It's not up to date, Lordship.
Just I want the statement of the victim girl under 164 and 161.
164, Lordship, will find at page 22 of their petition itself, Lordship.
Whose petition?
That is in the case diary, charge sheet, my lord, this is, my lord, mentioned.
Charge sheet is not quote unquote. Charge sheet is a substance.
Quote unquote, Lordship.
Charge sheet is a substance.
It is there, Lordship. I have taken marks, Lordship.
Sir, just go to it. Okay, we'll take it after day after tomorrow. You just, you just mark it. There are two statements. This and any medical test is
Yes,
there.
Lordship, already.
You just give it. Mr. B. Sharma, learned additional public prosecutor, submits that he may be granted some time to go through the case diary and assist this court. Prayer is allowed. Release this matter on 31st. Yes, what is this?
Yes, may I please, Your Lord. So this is the transfer petition. Lordship will find the order dated 22 to 24. By this order, the entire proceeding was stayed by a reasonable order. Now, what happened, the trial court has exceeded the jurisdiction and made an.
That will take later on. Just let us dispose it of, we'll see the on merit. Yes.
Yes.
What is the case and why you want to transfer? Tell us.
The matter relates to NI Act, Lordship. NI Act. So when the accused went to adduce defense witness, he has been threatened. All this analogous matter, four matter arising out of the same transaction.
Where is the straight statement?
Lordship will find the FIR judge and FIR law. As page 21, Lordship.
Who is this magistrate?
CGM Udalguri. CGM Udalguri, I think.
Now, what is the stage of transfer?
The matter has been stayed, Lordship.
No, state. No, you initially in NI Act was filed. Then you receive.
I'm an accused.
Accused. NI Act was filed.
Filed.
Summons were issued to you.
Prosecution witnesses were examined.
Ah.
Now I wanted to reduce defense witness because this matter relates to subletting the contractual work. Now this person, allegation is that they have executed and there is a liability, and against the liability check was issued. I wanted to reduce the evidence to show that they have not performed their work. So no bill was passed and everything. So I wanted to reduce evidence. My examination in chief was taken. Now it was fixed for cross-examination. On that day, there was a threat.
Where is that? Have you lost
That
any
is in the
FIR?
FIR.
Huh?
That is in the FIR.
You have lost the FIR.
Lost.
You want to respond to all these things? Have you filed affidavit?
Well,
You have filed affidavit.
well, not file my,
You want to file?
yes.
Okay.
But only thing with all respect,
Just,
Lordship.
learned counsel for the respondents submits that as certain factual assertions are made in the present petition, he would like to respond to such statement in as much as an allegation of putting threat by the petitioner has been made. Full stop. Prayer is allowed. List this matter on when?
Subject to your lordship.
No, it's you.
After 2 weeks.
After 2 weeks.
Otherwise, matters is fixed on 3/6.
Just after 2 weeks. In the meantime, interim order passed earlier shall continue. Give the list this matter on 3/6. Huh? What? When you say? After 2 weeks? Give a date after 2 weeks, Muslim.
Yeah, for 2 weeks. But in the matter, Lordship, item number 10, no? 10, item number 10, there is no stay order.
Just listen to us. Will be a common order on all the cases.
Divya.
You file an affidavit.
My lord, appearing for respondent number 2, my lord.
Respondent number 2.
One is stay.
For these matters as agreed to by the learned counsel for the parties, these matters are taken up together. Full stop. The উপর লিখবে তার আগে তার পিছতে the issue involves transfer of the
complaints.
How many?
4.
Four CR cases filed under Negotiable Instrument Act by the respondent number 2 against the present petitioner. Full stop. তারপর বাকিখানি লিখিবা। As the matter is under consideration before this court, the proceeding, further proceeding of the negotiable instrument cases, so and so, give all the numbers of all the cases. Give a list, Mr. Alam.
No.
Huh?
But in the meantime, NBW has been issued.
Just
That order may be kept in evidence.
Shall remain suspended. Any NBWA issued against the petitioner shall also remain suspended.
Deeply.
This court is disturbed to observe and peruse the order dated 13/5/2024 passed by the learned magistrate in NI case number 02 of 2022. Full stop. This court, while issuing notice of motion under its order dated 22/2/2024, directed that further proceeding, pass the following interim order. Inverted comma to inverted comma. Considering the submissions of learned itu Sailoba, order dated 22 to 24 or last part 2. Release this matter 3 weeks away. Also, when such orders were placed before the learned magistrate proceeded with the proceeding, ignoring such interim order. The reasons cited by the magistrate are as follows. Page 31, page 32.
33, Lordship.
33.
Fourth paragraph. However, it is to be noted that the said order stay by the Honorable High Court dated so and so was not done by virtue of speaking order.
Speaking order. Full stop. Full stop. Such recording amounts to undermining the order of a superior court. Order of a superior court. The magistrate further went to say the following. Pencil mark to pencil mark. Full stop. In view of the aforesaid, the aforesaid order be brought on notice of the Registrar General, Guwahati High Court, so that necessary corrective measures can be taken up. Full stop. A copy of the order be furnished to the learned Registrar General as well as the Register Vigilance.
Item number 9, 10, 11, and 12, today.
Since the magistrate has expressed the view and is not clarified by the earlier order, it is provided that until further orders from this court, the proceedings under negotiable instrument act so and so shall remain suspended.
I am not appearing in item number 10, man.
You are not appearing.
No, 9, 11, and 12. This is a separate thing.
Notice has been served, but no
Notice has been served. Okay. In except item number 10 to demand. Respondent number 2 instance. So item number 2 number to likhi diba petitioner last up. Though in criminal petition number so and so, though notice has been served, however, none appears for the respondent number 2. If in this order, Kaliratipa. Yes. Yes. That's money.
42.
On behalf of NK Sultan.
What is the affair?
42 minute case there is received. He was carrying the money. He says that he came to start business in Assam and for purchasing.
Whatsoever, what is the cognizable offense on the basis of which you have seized the money? Tell us.
That's what I could not make out.
If you could not make out, we'll immediately forthwith release. That's all.
Bank guarantee.
Why?
Some guarantee should be there because investigation is on.
What investigation? It is your responsibility to intimate the income tax. Even if there is problem, they will do. If it is a money laundering, it will come under enforcement director. You are sitting over yourself.
The money laundering will not come directly. There has to be a predicate offense. But thing is that if it is
maybe money is there, who is the power to keep this money seized like this?
No, if this procedure is related to NDPS case, some guarantee may be
you will give a bond
because he belongs to different state.
See, look, show me the case diary.
My lord,
case diary.
Only suspected, my lord.
You are
And
doctor, learned counsel for the petitioner. also heard Mr. D. Das, learned additional public prosecutor for the state respondent.
So far, offenses alleged, no materials. That is admitted position. Only suspected.
And by way of the present petition, an order dated 22/3/2024, passed by the Judicial Magistrate First Class, Bongaigaon, in Bongaigaon GRPS case number 17/2024, is put to challenge. Full stop. The brief fact of the case can be recorded as under. Where is the FIR, madam? Full stop. An FIR was lodged on
Annexure
huh?
3,
Okay.
24 to 25.
Full stop. Is as under. On 20/02/2014, at around 1:15 p.m., the IC of new NBQ GRP Investigation Center received an information that a male person is traveling in coach number A1 of Northeast Express FIR KYQ DN train number so towards New Bongaigaon, and there is a lot of stolen money in his bag. Accordingly, the present petitioner was searched and a cash amount of rupees 20 lakhs were recovered from his possession. According to the police, as the petitioner could not give any satisfactory reply about as regards about where he had brought such money and the purpose thereof, it was suspecting that this is stolen property. An FIR was lodged before the officer in charge New Bongaigaon GRP police station. First up, aforesaid FIR was registered as GRP case number so upor jitu dilo GRP case number so. Full stop. The petitioner was arrested and he was produced before the learned Chief Judicial Magistrate Bongaigaon, Assam, on 21/2/2024. Subsequently, the petitioner was released on bail. Full stop. Thereafter, the petitioner filed an application before the learned magistrate for Jimma of the money seized. Full stop. And such Jimma has been rejected by way of the impugned order. Where is that impugned order?
Order, Lordship, page Annexure 1, page 46.
Annexure 1, page 46. Rejected such Jimma petition, Jimma. Page
46.
What is this Annexure I?
This is a bail application.
Zimma.
Where is that order?
Order dated 22nd March 24.
What is the order?
The said report reveals that the investigating of the case is going on to ascertain the source of the seized money, and as such, the seized money of amounting to rupees 20 lakhs is required for further investigation.
Okay, rejected on the ground that the aforesaid money is required for further investigation. Full stop. This court has called for the case diary of the aforesaid police station case. From the perusal of the case diary, it is seen that it is seen that no sub materials has been, incriminating materials has been collected during the investigation to suggest that the aforesaid money do not belong to the petitioner or that it is tainted money. Rather, the petitioner has given certain explanation and record to show that this is an amount of money which he was carrying being a businessman. First of all, it is one method that whether such a huge quantity is permissible to carry under the extant law, and it is another method to say that said money is involved in commission of offense. Full stop. Therefore, in absence of any material to suggest that this is a tainted money from the material collected by the investigating office of authority till now, subject to further investigation, this court is of the view that the petitioner, who is a businessman, should not be deprived of the cash amount so seized, subject to, however, the condition that the appropriate authority like income tax, etc., may take necessary, initiate necessary proceeding permissible under law. Full stop. It is also important that circulation of money in the economy itself helps the economy, and keeping a cash amount in a police station under seized condition is also not in the interest of the economy. Full stop. Therefore, considering the method in entirety, the present application stands allowed with the following conditions. Bail bond of 20 lakh and all notes are order. They will register the serial numbers of the notes, take photographs. All serial numbers of the notes, take photographs, and then as and when it will be required, he will produce. As and when required, he will give a bond that he will honor the amount of 20 lakhs. Okay. Dispose of. Case diary is returned. Mr. Das, just I will keep the case diary for the timing for completion of this, the correction of the dictation. Yeah, I may return you tomorrow or day after. What is this?
My lord, the lordship could remember that 2021 there was a drive for my lord land brokers, and my lord everywhere in entire Assam, my lord, the drive was moved. And my lord, in this course, my lord, I was also arrested, and I am a I was serviceman. Also, face suspension. Lordship, can you see the FIR that contained in?
No, FIR we have seen. Now, what is your ground for?
Nothing, my lord. Nothing recovered from me. Only sale deed, my lord, that has been seized, which is from my ancestral property.
What is the stage now? Stage of?
Nothing, my lord. It's just in a dormant condition, my lord. No charge has been submitted.
No, that we understand. But to quash us FIR.
Yes, my part, my lord.
Huh?
My part.
Understand your part. There are some fundamental principle of law.
Quite right, man.
Is not it?
Absolutely.
So, what are your grounds here?
Basic ground is that, my lord, the Rajan Law's case 102, my lord, paragraph, that is clearly says that if suppose there is a, my lord, absurd, my lord, FIR, which has no any base at all, my lord, then, my lord, a person should not be sufferer of that, my lord, criminal investigation in the name of criminal. Lordship, here is a case, my lord, a common FIR has been filed. There is no any specific allegation against me either, my lord. And there is no any, my lord, material which has suppose under section which has been invited. My lord, they must, my lord, prima facie have a case in their hand. That I am a, my lord.
See, that we understand. It's not that two, three views are possible. So we'll have to balance here.
Right, right.
One is saying that when FIR itself is not making out any case.
Quite right.
One view. Other is that FIR is not the gospel truth.
Right,
Isn't it?
Quite right.
So therefore, investigation may bring out many materials.
Absolutely, man. Definitely.
It is not absolute facts. So during investigation, there may be many
Now,
things.
Lordship,
So therefore, in that context, the investigation and proceeded is not, there is no stay order.
let them show, my lord, that any materials against.
So that is not there. So we will like to see what are the materials collected against you.
But
And if there is no material, investigating
Yes.
authority may say that the final report against you. Why should we exercise that
But
power?
thing is that, my lord, can you see?
And there is a stage, all this you will have to answer. Today may not be possible, time will not permit. You will have to answer that why should we exercise that
But, my
power?
lord, the lordship,
You will have a chance at a stage.
guidelines is very much clear that within parameters, if I fall, my lord, then I have a good case. If not, my lord, I don't have any case, my lord. That is the simple thing.
Let us go through it. What are the materials? This may not be possible to complete and dictate today.
But,
My lord,
my lord,
that's why I submit, it is not that there is no material at all against him. According to his own statements, he is doing this business, selling, buying land and selling it to somebody else is done in his son's name. Now, from son's position, but different persons, but power of attorney, sale deeds are recorded, not in their own name. Neither he or in his son's name or in his own name. So these are materials, you know.
lordship, Thursday, my lord, can.
Thursday may not be possible.
The
Mostly.
next Tuesday, my lord. This is 2021. my
And
lord.
another thing is there, my lord, I talked to the SP crime branch today. They are contemplating for submitting the charge sheet.
You return
It
to
is not
deputy-
that there is not at all a material against him.
You return
No,
to
why
deputy-
other persons, my lord, deed, sale deed, power of attorney is in their position.
No, we know our 480 power is a limited, limited power.
Yes,
So
and
it
your
will
lordship,
not, we cannot stall an investigation and everything. These
We know
now,
the parameters, my lord, and we'll try to satisfy this honorable court that my case squarely covered that parameters, my lord.
Okay.
Tuesday, my lord, next.
when?
Next Tuesday, my lord.
6th of June. This matter on 6 will need. কারণ এটা লাগিব না? On the
Very little issue involving in this case, my lord. Whether on the basis of a non-cognizable offense, which is charge sheeted by police, proceeding can be sustained against the petitioner.
What about the steps?
Steps taken in due course, my lord, but it is.
Await service report
await
in
service
respect of respondent number 2 and list this matter after 4 weeks. Interim order pass earlier shall continue.
I would like to take fresh steps if your lordship permits me.
Okay.
Subject
Okay.
to condition that registry will provide me the consignment number to the petitioner for to track in.
No, you can have this. You can have this.
Lordship may
We'll-
kindly direct, otherwise they will not provide it.
No, you take steps, come down on the next date, that I have taken register, we ask registry to track on their own. Okay.
Lordship may record.
No, not now, you take steps. The learned counsel for the petitioner submits that as neither ID card nor unserved notice in respect of respondent number 2, unserved notice, nor any service report has been received back as regards service of notice upon respondent number 2, he would like to take fresh steps upon registered, upon the respondent number 2. Prayer is allowed. Accordingly, steps be taken within a period of 5 days from today. List this matter after 4 weeks with the updated service report, which including the tracking of the delivery from the postal department's track software. Track software, full stop. Tracking software, full stop. Interim order pass earlier shall continue till the next date of listing.
Deeply.
এসি শোনা নাই নাকি আছে?
My lord, this is a matter of watching, my lord.
Yes.
My lord, here the FIR is in page number 48, my lord. My lord, in this case, my lord, we are the resident from Myanmar, my lord, and we took a refugee in India. So when we are coming from Jammu to Assam, the car was intercepted, and while there was no, when there was no valid documents we produced, they arrested us.
Now, what is the prayer here?
Prayer is to quashing the FIR, my lord.
Why?
Because, my lord, there's no criminal activity, my lord, against us, my lord, because we have been issued the valid refugee card from UNHCR, my lord.
Now, UNHCR's valid refugee card is applicable to which country?
My lord, India respects the UNHCR country because I can substantiate my argument by providing an authority, my lord. Because a lot of judgments have been provided.
Today may not be possible, okay? We'll take it up. This is having some urgency. So, day after tomorrow? How many?
One difference, my lord, is that the CD has not been, the order was CD for,
Case diary.
but till date the CD was not received, my lord.
Okay.
My past 3 years it has not been received.
The case diary was called for from the learned District and Session Judge Kasar Silsar. However, the learned District and Session Judge Kasar, by its communication dated 18th of March 2024, has reported back that the Silsar PS case diary of Silsar PS case 1371/2022 is not lying with the criminal miscase number, if like A to silo, criminal miscase number 787/2022. However, it is also it is also reported that the learned session judge has already directed the concerned IO to transmit the scan copies of Silsar PS case number 1371/2022. However, no such copy has been received. In view of that, Mr. Goswami, learned learned additional public prosecutor, submits that he may be granted some time to produce the case diary in connection with
Silsar PS 1371.
Silsar PS 1371/2022. Full stop. Okay, list this matter on
Then 14
14th of June 2022. You have it. There are some recent judgments also.
There is a lot of judgments, my lord. Okay.
Rejection of my prayer, my lord, under section 311, my lord, is the subject matter in dispute, my lord. Fact of the case is, my lord, that the FIR was lodged, my lord, alleging house trespass and rape. On the day of the lodging of the FIR, I was arrested, my lord. Thereafter, my lord, after the evidence of all the witnesses were closed, we filed a petition, my lord, under section 311 that was rejected, my lord. Our contention is, my lord, that certain facts relating to 161 statement were not put to the victim. If these facts are not put to the victim, my lord, then we cannot use the contradiction in the argument.
That is your improvement of the case.
No, that will not be an improvement.
Why not?
Because my lord,
see, then we forgot to give this suggestion. We have forgot to cross-examine this. This was 161. There will be never ending.
I agree with that, my lord, but if your lordship finds, my lord, in the facts of the pattern circumstances, this was an inadvertent error.
What is your application? You say that my lawyer has not cross-examined, therefore give me a chance. Can it be a ground to under 311?
No, that cannot be in totality, my lord, but if we disclose all the question in the application, my lord,
you disclose the question. These are the questions which you left.
No, my lord, if we disclose all the question, my lord, the prosecution will come prepared, my lord. Then where is the ambit of the cross-examination will remain?
No, that is not the only criteria.
That may not be the only criteria.
This is not the only criteria.
Or
see, whatever, we'll have to give a reason.
my lord,
Your circumstances is that you have cross-examination is done, she has gone, subsequent examination, it is at the stage of delivery of judgment.
no, my lord, it's a stage of argument, my lord.
It is a stage of the argument. Now you come and say that these are the questions I ought to have asked, I have not asked. So therefore, call the witness. Can that be a principle of?
Only the one witness.
Huh?
Only one.
That is one witness, call her to cross-examine. Is it what is the principle of law under 311?
The principle is will not.
Time has saved you today. Nothing
Will
more to-
satisfy this on Lordship. Let it be on Friday, Milord. Will satisfy your Lordship. Milord.
So
On Friday,
confident.
very confident. On Friday, Lord.
Friday may not be possible. There is already a stay in your favor. Trial is stayed. Musime? 10th of June. Rishabh, go through it. As
Lovely.
agreed, as prayed for the Lanais Council properties, this matter on 10th.
Interim order to continue.
Interim order pass will continue till the next date of listing.
I'm okay.
We'll start it. It is still 4:30. 4 hours, start it.
I mean 21.
But similar.
Yes, in fact, your lordship, because I am, my reading of the matter is, I am appearing as an amicus in 31, that I am the principal accused. The allegation against against the co-appellant.
We will think that you are not representing anybody. We want your assistance. These are the facts. These are the evidence.
Yes.
This has rightly been done or wrongly been done.
Yes.
Decision will take, but we want you as an amicus.
30. Has submitted my lord the compilation of limited arguments calculations.
Record please.
Yeah.
Record LCM. There is a limit to everything. It's a case of 2005. If necessary, we will continue to sit.
Like, otherwise, the core issue is not.
No, we know that. And what is how many pages of your written argument? Tell us.
70 pages.
70 pages. We'll not even
We
look
have
in.
given the details because there is a 46 number of prosecution offense. So we have bank accounts, my lord, 6 numbers of prosecution is very important. Because at the time of trial, that is my lord we have prepared for afternoon meeting. And we have given numbers of my lord judgment of.
See, judgments rely on one subject, not more than one. If you rely on more, then there will be cost. Most apt and applicable judgment. More particularly when it is your senior. Where is the LCR? I think there is a paper book. Huh? Give the paper book.
Paper book is in 3 volumes. Sir.
3 volumes. We'll finish it off. That's all. We know that only. May not be today. Yes.
Lordship, the allegation, I'll just give you a lordship a background of the allegation.
Give the background.
So there was this company called Assam Farmer Friends. It's
Okay.
so they had a account at SBI, your lordship. Then that account became that account became NPA. So all transactions in that account was blocked. Then what they did, the allegation, this is the allegation. They went to the SBI branch in Howli, the agriculture development branch. Then fictitious accounts were created. Now there is a concept, your lordship, called invoice purchasing. It's called purchase of bills or invoice purchasing, same thing. What happens is, your lordship, that today if I am a seller and then he is a buyer and I sell something to him and I get the money after 2 months. Then instead of 2 months later, I'll get rupees 100. So instead of waiting for 2 months, I can carry that invoice to the bank. Bank will buy it from me and pay me 95 rupees now. So what my profit is that instead of waiting for 2 months for 100 rupees, today I get 95 rupees and 5 rupees is the bank's profit. Now these accounts at the Howli branch, they appeared, they went before the branch manager of that branch and said that we have sold XYZ goods to this company called Inputs Corporation. And these are the invoices. So accordingly, those invoices were purchased. then the amounts were paid to them. The allegation is this amount, some amounts were sent to Input Corporation and some amount was rerouted to clear the original NPA.
Okay.
Original NPA. Now, there is some money in Inputs Corporation account. With that, they paid some amount back to the bank. And the original account was made active again. Then later on, what happened with the bank's money, they are repaying, effectively, they were repaying the loan.
Okay.
The allegation, Your Lordship, is against the accused in item number 32. Otherwise, it's a very smart mechanism that they have formed. Charges were formulated.
Now, who are these people? These persons are their bank officials or?
Item number 30 is the bank office.
Item 30 is bank official. That is, what is his name? Pranaranjan, he's a bank employee.
Bank employee.
He's still alive? Okay.
Last 1 month back.
Huh?
He's a 85 years
So he will spend his rest of life where? In residence or in jail? He is what? Okay.
I come to him last. I do not know today.
So he is the bank employee. And who are the others?
31 and 32 are the customers and they are the owners of the Assam Farmer Friends.
Okay.
Which is the original company which was NPA.
Okay.
And the allegation, in fact, the principal allegation is against them.
Right.
The allegation is that firstly, 420 is there, but the allegation is that you have forged documents to create those fictitious fictitious accounts. So the allegation is under 465 and 471 principally. 420 is there. And against him, because the allegations against me have been proved, it's under 120B and 13 of the PCA.
Now, what are the 120B in the ingredients against him?
The trial court has felt that yes, it is proved. Because
suppose it is a forged documents and it is given to a bank official, just overall. Now it is a forged document. He is not beneficiary until and unless you say that he is a beneficiary of the entire transaction.
Yes, that is true. That is what the learned court below probably felt, Your Lordship, was because as a branch manager, he had some duty to exercise due diligence while in
due diligence and part of conspiracy is two different things.
Very much so.
Two different
Very
things.
much.
And there may be error of judgment.
Yes.
But there may not be criminality attached to it.
Yes.
Okay.
So that is in the crux, that is the allegation, Your Lordship. If I may take Your Lordship to the FIR, there are 3 FIRs.
Okay. We'll get the FIR in which paper book? Part 1.
Part 1, Your Lordship, volume 1.
Okay. Volume 2, volume 1. Okay.
Principally, the allegation is same in all the 3.
Page
1. So, P.R. Bhattacharjee is the accused person, appellant in item number 30, and Mrityunjoy Ghosh and Madan Kundu, director of Assam Farmer Friends Private Limited, are the appellants in 32, 31.
Who is representing this? Madan Kundu and yeah?
I am appearing as amicus.
Okay, amicus. Okay. Who were their lawyers?
Mr. H. Deka and Miss Chakravarti, perhaps their names are shown in the cause list.
Last time, last location,
Okay. Okay, Madan Kundu. Okay.
I'm appearing as amicus in that matter. So the FIR, Your Lordship, if I may read, information exists that Shri P.R. Bhattacharjee, while posted and functioning as branch manager Howli, Agricultural Development Branch of SBI, during 1985-86 entered into a criminal conspiracy with Messrs. Assam Farmer Friends Private Limited, Shri Mrityunjoy Ghosh, Managing Director of the said Messrs. Assam Farmer Friends Private Limited, and in pursuance of the said conspiracy, dishonestly purchased demand drafts, bills of Shri Madan Kundu, Gopinath Kundu and Manoranjan Ghosh, after allowing them to open current accounts introduced by Shri Mrityunjoy Ghosh, MD Messrs. Assam Farmer
At
Friends.
that point of time, 31 lakhs.
41 lakhs. Total amount is all 42 lakhs at that time. And subsequently sanctioned demand draft purchase limits of rupees 31 lakhs, rupees 4 lakhs and rupees 4.10 lakhs respectively, only for the purpose of negotiation of bills, knowing or having reasons to believe that they have neither personal business establishments of their own, nor have they any fixed assets, as a result of which an amount of rupees 8,14,173.55 has been returned unpaid by the Drohi branch, that is SBI Sipur branch. All the bills noted underneath were drawn on Messrs. Inputs Corporation of India, Sipur, Howrah, and were presented through SBI Sipur branch. All the consignments were booked through Messrs. Ashoka Transport Agency. The commodities dispatched are shown as some seeds, linten seeds, again some seeds.
Now, who is this Gopinath and Manoranjan?
Gopinath and Manoranjan were originally accused, but later on they became approvers.
They became approver. Now, what was their role? Just for today's understanding.
Their role is, initially they are the persons who have opened these accounts. They are the only two, in fact, real persons or persons who could be traced, who opened those current accounts at Howli. The rest of them could not be traced. And they also said that yes, we have sold some goods to.
But there is nothing to be sold.
That is the allegation. Because some amount was returned. What they have done, in fact, in Assamese, there is a place called Masotelere Del Bhazai Lordship. That is what has happened. So they have taken money from the bank, returned some money to
They gave a forced document to bank.
Yes.
That is kind of a promise.
Yes.
That this is 100 rupees coming to me.
Yes.
Give me 95 rupees. You take the 100 rupees.
Yes.
So that
95 rupees, some part of it was given to Inputs Corporation. Some part of it they used to repay their own loan. And when the invoice became due, Inputs Corporation repaid some amounts because they had some money, but obviously 100% they did not have. So then finally that cycle, your lordship. So the commodities dispatched are shown as so and so, so and so, so and so. All these accounts were opened with an initial deposit of rupees 500 each.
Tell us, just let us understand today. So we can understand the crux of the prosecution case. This is the prosecution case.
Lordship.
Fraudulent opening of account and this whatnot. Now, who are the star witnesses and what are the exhibits on the basis of which conviction was?
Now, the star witness according to the CBI is PW6.
Who is PW6?
PW6 is an employee of the bank. He has laid down, his name is Pradip Kumar Thakuria, and from March 86 to 89, he was posted at the Howli branch of SBI.
Okay.
So he has laid down, given all the procedure of how a current account is to be opened, how invoices are to be purchased, what are the limits, where permissions are required, where it is not, what is the scope of, what are the powers given to the branch manager, because the accused number one, it was the branch manager. Till what limits he could have done it on his own, what he could not have. He has laid down all the procedure also. And the other star witness, your lordship, is, though it's not a star witness, where heavy reliance was given, was the handwriting expert. Because, your lordship, the principal allegation against the other two accused persons is that they have forged, or somebody has forged documents to create two fictitious entities. One entity is the account holder and one entity is Inputs Corporation of India, which has sold. So for that, your lordship, the heavy reliance was placed on the opinion of the handwriting expert. And on that basis, firstly, the learned court below held that the appellants in item number 31, they are guilty of the offences under offences of forgery and using a forged document as genuine under 467, 465(7) and 471. And since those offences were proved against us, and he was found to be involved in the overall conspiracy, so under 120B, he was
brought in.
He was brought in, and then section 13 of the PC Act. So my submission, your lordship, is I went through almost all the principal witnesses. There is one major loophole, your lordship. Otherwise, CBI has done a very thorough job, your lordship. Everything was taken care of. One loophole, perhaps, in the way the handwriting expert gave his opinion, the way the samples were collected, and the reasons given, your lordship.
Now suppose that handwriting expert's evidence is gone.
Lordship.
Then what will happen?
Then there is a issue, your lordship. Because otherwise the law is writing expert's opinion. If it is, court can completely depend on it without seeking any corroboration. Here corroboration was sought for. Now, and out of the 4 witnesses who corroborated, PW 38, 12, 14 and 27. 2 of them were already hostile.
Okay.
And 38 and 45, one has said that yes, I know something, not regarding the handwriting, regarding the identity. Because one of the allegations also is that Inputs Corporation of India, their owners, I am impersonating them also.
Okay.
The appellants in 31, that they are actually the owners of the fake owners of Inputs Corporation of India. They have stated, these 2 witnesses. One has stated that yes, I know that this person has an alias called this. But then later on in cross-examination, he has gone and said that yes, I came to know during the investigation because the IO told me. And the other one is the sole remaining witness who has said that yes, he also has an alias called so and so. But regarding the handwriting, there is no corroboration apart from the witness. And once that goes, because impersonation is not a charge brought against me. The charge is only for forgery, your lordship. Then perhaps
let us do one thing. You just prepare a note for the hearing. I'm not saying that it's a written argument. Because these are, we need not worry about these voluminous.
Yes, yes.
Issues will be very
yes.
pinpointed.
Yes, sir.
We do not need 70 pages argument. Isn't it, Mr. Paul? We do not need 70 pages arguments. What are the charges? What are the materials? How you have established? What are the requirements? That's all.
Yes, sir.
So when?
On 20th of June.
This is a scar in the High Courts. So 20?
On 20th of June, Lordship.
No,
20?
June.
28th of June. Okay. 28th of June. Don't show all this. Argue it.
Not of 25th, Lordship.
25th.
25th.
But will it be able to finish by?
Yes, yes. On one day, we will not be able to.
No, that's why I'm saying. Will it be able to finish before vacation?
Let
we can start on
25th, let it continue thereafter.
I will continue. Huh? 20.
20 lordships, that Sakma case has been fixed.
Yes.
That is a very voluminous.
Okay. 25th. We'll see if necessary.
We'll continue.
But we'll complete it, this
Yes,
case.
yes.
We'll not.
Yes.
Heard Mr. KP Pathak, learned amicus. Also Mr. Paul, learned counsel, appearing for appellant in criminal appeal number 149, 2005. Mr. KP Pathak in criminal appeal number
175.
learned amicus. Paul is so and so. Mr. Haloy for the CBI. The hearing remained unconclusive due to paucity of time. Let this matter be fixed for further hearing on
25th.
25th of June 2020. Just you have that, and if possible, if you can give it the day prior on 24th.
Yes.
Huh?
Deeply obliged.
How to make a look for the কি দরকার তুমি লেখেন হ্যাঁ আচ্ছা তুমি এখন লিখে দাও yes anything left
Criminal appeal of 2012.
If the
We are going through the my lord evidences, my lord. It's not a Perhaps may not be a case for my lord, interference, my lord.
Now it's a case of injury.
Injury, my lord.
Who is the injured?
Injured, my lord, are my lord. PW1, my lord. Perhaps, my lord, may be a case of 307, my lord, but he is convicted under 324. Because the injury that is caused all in the vital part.
Who was the injured?
PW1, my lord.
How many witnesses examined?
My lord, total.
Seven witnesses.
Yes, ma'am.
7 witnesses. None appears for the appellant on call. List this method tomorrow. Mr. G. Pathak, come forward. This none appears for the petitioner on call. List this none appears for the appellant on call, though Mr. MP Goswami, an additional public prosecutor, is present. This matter is pending since 2012. First of, considering the same and in view of non-appearance for the appellant on learned counsel for the appellant on call, this court has requested Mr. G. Pathak, learned counsel, to assist this court as amicus. Full stop. Mr. Pathak has readily accepted such request. Accordingly, registry to list this matter day after tomorrow for hearing, showing name of Mr. G. Pathak, learned counsel for the learned amicus. Just Mr. Just you let him go through this record and show us. I think the statement of the injured victim remain unshaken.
Unshaken.
No eyewitness is required.
No, it's required.
And the medical evidence corroborated. Matter and
Absolutely.
subject to what Mr. Pathak says. Just go through it.
In 33, on Novin Das, he is out of station, my lord. Actually, he will reach God tomorrow. List day after tomorrow.
This is what is this case?
I have no idea.
Yes, Mr. Pathak. Yes.
I have also not seen because they have some.
Because already
for an adjournment, my lord.
okay. None appears for the criminal revision petition.
It's a revision. my lord.
Both through court. Okay. None appears. No. It is submitted by Mr. G. Pathak, the learned counsel, appearing on behalf of Mr. N.C. Das, learned senior counsel, that Mr. Das is having some personal difficulty today. Full stop. Accordingly, he prays for an adjournment. Prayer is allowed. List this matter in the list this matter on given date. Okay, list this matter after entering Bihu vacation. Sorry, summer vacation. Mr. Kotoki, there is no scope to dismiss for default.
No.
That is the difficulty in this bench. What about revision? Revision we can, no? On merit we can decide. Yes.
May I please Lordship, at least adjournment, I seek adjournment for 2 weeks, at least Lordship, because after the expiry of my
I
senior.
think everybody were happy that this court will sit only for a half, one half. So nobody is there, no expectation that it will reach,
Yes, my lord.
is that it?
Clarence.
Okay, agar order to party. You on behalf of your senior is?
My senior was dear Gogoi.
Ah.
I'm,
Okay,
yeah,
it is submitted that the counsel, Mr. D.R. Gogoi, representing the petitioner, has in the meantime expired, and his junior, MS
yeah, ma'am.
T. Ahmed, submits that she may be granted a 2 weeks time to
Get some instruction from my
get
client.
some instruction from the petitioner. Prayer is allowed, please this matter after the ensuing summer vacation. In the meantime, the learned counsel may obtain instruction. Yes, Kotoki.
IA has also come, my lord. Actually, if your lordship goes through the evidence of the victim, my lord, no offense of sexual acts has been.
Where is the IA?
The paper book is ready, if your lordship can take up.
List this
blame-
IA. I will not fix it in hearing. List the IA criminal 443/2021 on Monday next in the order column. Huh? Objection has also been filed. We'll
Fine,
see.
mine.
Huh?
If your lordship, no offense under POSCO Act.
Huh?
No offense under POSCO Act.
Okay, we'll see that. If no offense, then we'll allow the bail and fix it for hearing 2020 and we'll see after 10 years. Yes, on Monday next, then give that. Orders. Yes.
Only given under that lordship.
Huh?
The main appeal has come up for hearing, madam. IA dispose of man in 37.
2022.
Plus.
Okay. When?
Lordship 25th July.
Okay. On the prayer of the learned counsel for the appellant, matter stands adjourned and be listed on 25th of July 2024 in the 2024 in the hearing column.
Lordship has wrongly come in hearing list, it should have come into orders. There is a order of this code itself. Here,
Okay. In view of the order passed in,
I am giving the date, Lordship. Just a moment, Lordship. So, the Lordship has already had us.
I can understand.
And only in 39,
Hmm.
that was not before the Honorable Court. So Lordship has tagged 38 with 39 because two accused person. And here,
this was important.
yes, here what has happened, Lordship, here prosecution has failed to prove the recovery. From me, 1
Okay,
kilo 18 grams was
who
recovered.
is for the other appellant, criminal appeal?
DK Medhi, madam.
Okay, list this matter, IA to likhiba. List IA criminal 888 of 2023 in the orders column on not
Fourth, if it is possible.
fourth is
If it is
possible.
possible on Friday, I will be highly obliged.
No,
Lordship.
Friday, it's many cases
Then
are
let
written.
it come on fourth, Lordship, because
See, after completion of this, I will have to correct and sign for almost 50 orders.
why I am placing, Lordship, today 725.
No, we
pages in
understand. I
custody.
can now recall it. This matter I can recall now.
It can be on Tuesday, I shall be highly obliged, Lordship.
Fourth,
Fourth,
sixth of the.
as your Lordship. Sixth. Deeply obliged, Lordship.
Order.
For orders, let it come on an order column, Lordship.
Order.